C4 of CI 91 implies that even, in determining that Rule 69(4) implies that even amendments are not to be granted. And C, that the court fundamentally erred in failing to appreciate that its discretion ought to be exercised in accordance with Article 296 of the Constitution. My lords, it is our respectful submission that there is nothing whatsoever in CI 99 that renders Order 22 of CI 47 inapplicable. And we would respectfully ask your lordships to take cognizance of this Supreme Court's decision in the Republic versus High Court General Jurisdiction, Accra, ex parte Magna International Transport Limited, applicant, and Ghana Telecommunications Company, interested party. And that is civil motion number J5/66A/2017. A decision of 7th November 2018. And in that decision, your lordships determined that an earlier decision of your lordships, which had indicated that an application for stay of proceedings in a case pending before the Court of Appeal could only be brought before the Court of Appeal. Your lordship decided that that earlier decision in the ex parte Abu Dhabi case was in error, and therefore your lordships made it quite clear that nothing in the amended provision that was being relied on, nothing in that amendment provision constituted a repeal of rights that were in the CI 19. My lords, by parity of reasoning, we are respectfully inviting this court not to proceed in accordance with this earlier ruling, but to review that ruling so as to enable interrogatories, so as to grant leave for interrogatories to be served. And my lords, I respectfully rely particularly on the following passage in the ruling of Justice Bain, where he says that thus rules 21 and 28 of CI 19, which enable the trial court to have the first opportunity to stay proceedings before the appellate court becomes seized of the whole appeal, was just a crystallization of the well-known and time-tested principle and practice. Indeed, in such a situation, it is our considered view that any legislation that seeks to alter the settled practice and the settled principle and practice must be expressed in language on the ground that there is a presumption against implied repeal. My lords, your ruling on the 19th of January involved implying a repeal of Order 22 of CI 47. And this is what your lordship said. We are strictly bound to comply with CI 99, and therefore we will not apply Order 22 of CI 47 of 2004 in this circumstance. We accordingly refuse to grant the application, and same is accordingly dismissed. So your lordships, in effect, were saying that you have CI 99, you are strictly bound to comply with it, and therefore you were not in a position to grant us leave to file those interrogatories. Now, my lords, the provisions in CI 99 regarding timelines for an expeditious hearing nowhere explicitly say that interrogatories cannot be accepted. There's nowhere in CI 99. And therefore, your lordships could only be proceeding by way of an implied repeal arising from the timelines provided in CI 99. And we respectfully say that that was a fundamental error. My lords, we rely respectfully on the persuasive authority of the decision of the Nigerian Supreme Court in a case that has been referred to in our jurisdiction as well during the 2013 election petition judgment. That is the case of Abubakar and Yar'Adua. And my lords, for what it is worth, we will respectfully submit a copy of the full judgment in that case in respect of this particular issue to the court. That was a decision of the Supreme Court of Nigeria in 2008, January 2008, and I respectfully refer to a few passages in that ruling, including the following from the lead judgment of Nikki Toby, JSC, Justice of Supreme Court Nikki Toby, where he said, the Court of Appeal, in rejecting the application to administer interrogatories, said that it will impede speedy trial of the case. Courts of law cannot sacrifice the constitutional principle of fair hearing at the altar of speedy hearing of cases, when the content of the speedy hearing is not in consonance with fair hearing in the sense of availing the parties, as in this appeal, the right to administer interrogatories. A party who is entitled to administer interrogatories and is denied that right is denied the right to fair hearing. And when I say that, I'm not oblivious of the law that speedy hearing is one vocal and important aspect of fair hearing. The point I'm struggling to make is that speedy hearing of a case which denies a party access to pre-trial evidence, such as interrogatories, is not fair, as it runs contrary to the constitutional principle of fair hearing. And, my lords, it is further stated in the copy that we'll make available at page 17. It is further stated, I'm in entire agreement with the Court of Appeal when the court held that full opportunity should be given to parties in the interest of justice without due regard to technicalities. Gone are the days when courts of law were only concerned with doing technical and abstract justice based on arid legalism. We are now in days when courts of law do substantial justice in the light of the prevailing circumstances of the case. And on the next page 18 as well, it is stated by His Lordship Justice Toby, I do not agree with learned senior advocate that the Court of Appeal drifted into the realm of sentiments when it held that in a presidential election every opportunity should be given to parties to ventilate their grievances. The Court of Appeal is very correct. I do not see any sentiment. Now, my lords, these were clear statements of the Supreme Court of Nigeria, which we would submit are of persuasive authority. And at page 22 also, there is a clear statement to the effect in refusing the petitioner's appellant's application, the court below in its ruling of 25th September 07 said, I've listened to the learned senior counsel on all sides, and I thank them for their industry. I'm of the view that the answers being required by interrogatories and particular sorts can easily be obtained from witnesses during the hearing of the petition. In an election matter, anything that will impede speedy trial must be avoided. In the circumstances, I refuse the application and it's hereby dismissed. That was in the lower court. And then the court proceeded. I think with respect that their lordships of the court below were in error on their conclusion. They failed to consider the purpose sought to be achieved by the application for the delivery of interrogatories. There is no doubt that there was the necessity to hear this case expeditiously, but the ends of justice ought not to be sacrificed just because of the desirability to have the case disposed of speedily. And then they continue with a number of sub-points, and then this passage ends. I would like to say here that a more widespread use of interrogatories in our system in Nigeria will in fact aid the speedy dispensation of justice, because answers are delivered by affidavit evidence which puts the person upon whom they are delivered at the risk of being commuted for perjury if he does not truthfully and fully answer the questions. So, my lords, the clear indications from these passages of the judgment are that, in fact, interrogatories serve the interest of expedition. And I would respectfully submit that is an important consideration in this case, which we urged before this court in our application for leave. As we clearly indicated, the provision of answers to the interrogatories would facilitate an expeditious trial. We also respectfully wish to draw your Lordship's attention to a statement made in the same Nigerian Supreme Court case by His Lordship Justice of the Supreme Court Tabai at page 26 of this report that we will make available. And His Lordship says, I took time to study the 27 of them, that is interrogatories. In my consideration, the answers to these questions are peculiarly within the knowledge of the fifth respondent. Interrogatories and the answers should be put in evidence by the party who wishes to rely on them, and admissions made in a reply to interrogatories are conclusive of the facts admitted. I do not agree with the reasoning of the court below that the answers being sought by the interrogatories can easily be ascertained from witnesses during the hearing of this petition. It is my view that the application with respect to interrogatories was wrongly refused. It ought to have been allowed. And finally, my lords, in this and this is at page 30, where again it is stated that this procedure will certainly narrow down the issues in controversy and will facilitate the quick and early disposal of the petition. It is not a novel practice. So, my lords, our submission is that there is no repeal in CI 99 of Order 22, and we would respectfully invite your lordships to be guided by the wisdom of the Nigerian Supreme Court and its various judges in its consideration of interrogatories. I would also respectfully refer your lordships to the work of Justice Marfo Sang, A Practical Guide to Civil Procedure in Ghana, in which at page 107, actually I think those were in the days before he became a lordship, but at that page 107, and his lordship adverts to the use of interrogatories and provides a piece of practical wisdom that we have been guided by in our preparations for this petition. He says that the answers to the interrogatories, which are formulated in the form of an affidavit, may be put in evidence by a party at the trial of the action. Now, my lords will notice that in the witness statement that we have filed, in one of the two witness statements, the witness actually makes reference to the fact that we have filed not only the leave for interrogatories, but we also filed a request to admit facts, all of which are within these pre-trial processes. And in the case of the interrogatories, if leave were granted and those answers were available, then as Mr. Malfoussan as he then was?
No, I think he was in the Court of Appeal.
As a writer. As a writer. As a writer.
Exactly. So the indication that has been given in that witness statement is that we would expect that the answers to those interrogatories would be available to put in evidence, which will then limit the scope of controversy, and therefore it would limit any additional recourse to oral testimony or to testimony that would be regarded as controversial, because it would be in evidence in a manner which is regarded as uncontested. My lords will also appreciate that in respect of the matter concerning the request to admit facts, which is not an issue in this review, but I'm just drawing attention to it in the context of how we believe that these pre-trial processes actually aid to achieve expeditious justice. Because essentially, both the responses to the interrogatories and the responses to the request to admit facts narrow down the issues. And it is as a consequence of that, for instance, that we are now in a position, instead of having 5 witnesses, to limit ourselves to 2 witnesses. Because the request to admit facts, for instance, within the 14 days that those facts are requested after the 14 days, if they are not admitted, they are taken, if they are not answered, they are taken as admitted. So we are making a search to determine when it was served on them, and then we will be able to seek leave, if need be, for a supplement to the statement, to the witness statement, which would then enable that to be in evidence. So, my Lord, we are grateful to Mr. Malfoussan for those words of practical guidance in his treatise on a practical guide to civil procedure in Ghana. Now, we respectfully submit that the same approach of this court in Republic and High Court Ex parte Magna International Transport, that same approach is found in this court's decision in Mona and the Attorney General. Where again, that is 2013 Supreme Court of Ghana Law Report, page 502. That court was faced with an issue arising from an amendment to Rule 55. And that amendment was by reference to Rule 71B in CI 74. And as it turned out in that case, Rule 71B actually had a heading, no review, suggesting that it was purporting to prevent reviews. And this is what the lordships concluded. And I refer to the judgment of Justice of the Supreme Court Benin at page 512. Thus, when the Rules of Court Committee was charged under Article 64(3) of the Constitution with the responsibility of enacting rules to regulate the conduct of the practice and procedure in presidential election petitions, it meant the substantive laws were different from what the committee was empowered to do. The committee was not empowered to amend the substantive law without express authorization. One such substantive law in place is the right of review given to the Supreme Court by virtue of Article 33(1) of the 1992 Constitution. Review is not a matter of mere procedure, but an important and substantial constitutional right. Any attempt to alter the right of review will be ultra vires the functions of the Rules of Court Committee. And any attempt to remove the Supreme Court's review jurisdiction or a party's right to apply for review, except through an amendment following due procedure under the 1992 Constitution, will be unconstitutional. Now, our argument is by parity of reasoning. We're not saying that exactly the same circumstances are here. We're saying that by parity of reasoning, if there were intended to be a repeal of a well-established process, such as the pre-trial process of interrogatories being filed or other discovery processes, if there were an intent to do that in CI 99, it would have had to be very express in order to achieve that result. That result cannot be achieved by means of an implication being drawn that the timelines do not allow for that.
Mr. Chikata?
Yes.
Is there a difference between a constitutional provision that is impliedly taken away because of CI and a provision that is resorted to in order to do justice? Is there a difference? I'm thinking of your parity of reasoning, and I'm wondering why you would compare apples and oranges in that way.
My lady, as I indicated, we are not suggesting that they're exactly the same circumstances. But in each case, in the case of the ex parte Magna authority, which says that there can't be an implied repeal, in the case of the Bernard Mona situation, which says that a rule of the Rules of Court Committee cannot take away a constitutional right. In each case, we are talking about an existing right, an existing practice and procedure. If it is being sought to be taken away, one, as ex parte Magna says, it has to be explicit. It can't be done by implication. And two, in the case of the constitutional situation, the position is that it cannot even happen at all. So that is in extremis. That is in extremis where it is simply impossible. But I'm saying that...
That is why I'm wondering why you would compare a situation in extremis with the situation that you are talking about and reasoning that by parity of reasoning.
Because in principle, in both cases, you do not have an express repeal of an earlier CI. You do not. In both cases, there isn't. In fact, that is why in the Bernard Mona case, even though the Rules of Court Committee may have thought that they were taking away the power of review and they put no review at the top, even though they put that, the court decided that it did not have that effect. Because looking at, and my lord, again, this is a matter of looking at the language. The Bernard Mona decision is absolutely on all fours because the court looked at the terms of the amendment. The terms of the amendment showed clearly that it was not seeking to review. I'm sorry, it was not seeking to take away the power of review. The terms, and we are saying respectfully that the terms of CI 99, nowhere do the terms of CI 99 seek to take away the power to have interrogatories served in Order 22. So there is a clear parallel because the court is saying, let us look at what the so-called amendment is trying to do. Let's not even bother with the heading. The people in the Rules of Court Committee may have thought that they were taking away the right of review. But let us look at the words. And those words did not indicate that the right of review was being taken away. In the same way, we are respectfully saying to your lordships that the words in CI 99 nowhere say that they are taking away the powers under Order 22 of CI 47. Nowhere. And I would respectfully challenge anyone to point to any provision in CI 99 that seeks to take away what is provided for in Order 22 of CI 47. And my lords, we would respectfully also draw your attention to the provision in Article 1294 of the Constitution, which states that for the purposes of hearing and determining a matter within its jurisdiction and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority expressly or by necessary implication given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law. So it is without a shadow of doubt that those provisions in CI 47 Order 22 in respect of pretrial procedures, those provisions are available to the Supreme Court. And it is on the basis of those provisions that the Supreme Court in 2013, in a petition brought by Nana Addo Dankwa Akufo-Addo, had recourse to Order 22 of CI 47. Our submission is that it cannot be that just because this petition is by John Dramani Mahama, it cannot be that it cannot be.
Please, let's try to.
My Lord,
it's okay.
Respectfully, my argument is that there cannot be a different interpretation of the law.
With due respect, if the 2013 case is cited, then it will be clear to all of us. That's my worry. What I'm saying is that if it is a reported matter, yes, if it is cited in course of arguments, yes, that would be the appropriate thing.
Mr. Chigata, and additionally, the 2013 election petition was not done under CI 99. So that is the change, rather than the personalities involved. I think you
Yes, my lords, I believe I have indicated that nothing, that's my first argument, nothing in CI 99 took away that authority. I've indicated that. And therefore, and building on that, I'm saying that it cannot be any different from one petitioner as against the other. We'll leave out the names of individual petitioners, but it cannot be different as between one petitioner
Mr.
or
Chikata,
the other.
can you explain to me how come the Rules of Court Committee was seized of this matter after 2013 and still did not make this provision?
And so what?
And still did not make this specific provision that you are saying somebody benefited from, and so everybody must benefit from. How come the Rules of Court Committee had another opportunity to make rules and did not say anything about it?
My lords, as I've indicated in answer to your previous question, I frankly have no knowledge of the deliberations of the Rules of Court Committee, and I'm not, with respect, willing to go on an expedition into the minds of the membership of the Rules of Court Committee as to how come they did this or they didn't do that. That, respectfully, is completely outside my terrain. What is within my terrain is what they have provided in CI 99. And in CI 99, nowhere do they say Order 22 is repealed. Nowhere.
CI 99 has repealed Order 40, Order 22, or CI 47. We just said that. You just read the ruling, the basis of your Grant A. We are strictly bound to comply with CI 99, and therefore we will not apply Order 22 of CI 47 of 2004. We did not say CI 99 has expressly or impliedly revoked or repealed Order 22.
Yes, but
yes. If you allow me to lie, we're just saying that we cannot apply, in the circumstance of this case, we cannot apply Order 22 on interrogatories. That is all that we said.
Yes.
We never alluded that CI 47 Order 22 has been amended or repealed.
Yes, but my lord, with the greatest respect, if the circumstances are no different,
Yeah.
if my lord, may I finish my sentence? If the circumstances are no different, except for the fact that there is now CI 99 providing a certain timeline for decision making, we are submitting that Order 22 is still capable of being operated within the timelines that are given in CI 99. Nothing stops Order 22 from being implemented and the timelines not being complied with. Nothing.
If you note, the very first reason in the ruling of the court is that the crucial issue of relevance has not been established in the petition. That was a very first reason.
And that crucial issue of relevancy is referred in the ruling paragraph, the sentence just before that. Interrogatories under common law is discretionary. It should be granted or refused. Interrogatories under common law. We did not seek interrogatories under common law. We are seeking interrogatories under Order 22 of CI 47. And we are saying with respect, that if it is a question of relevancy, I mean, respectfully, if it is a question of relevancy we are talking about, how can it not be relevant that an interrogatory that seeks to ask, for instance, question 7, when did Mrs. Jean Aduko-Mensah, the chairperson of First Respondent and the returning officer for the presidential election, first realize there were errors in figures she announced in her declaration of 9 December 2020? 8. How did Mrs. Jean Aduko-Mensah, the chairperson of First Respondent and the returning officer for the presidential election, get to realize there were errors in figures she announced in her declaration of 9 December? 9. In respect of the purported corrections made to the figures in the declaration by First Defendant, was there any prior process of conferring with agents of the presidential candidates? 10. Did Mrs. Jean Aduko-Mensah, the chairperson, present Form 13 to all the agents of the presidential candidates to sign? And if so, did all the agents sign? 11. On which date did Mrs. Jean Aduko-Mensah, the chairperson of the First Respondent, post a copy? They can be asked by means of cross-examination. We made it quite clear that, in fact, being able to have those questions addressed in interrogatories saves time, because then you don't have to go into them in cross-examination. Why would I spend, questions in cross-examination dealing with something that has already been answered on oath? That is why we say that we have been practically guided by that wisdom, that if it is stated on oath, we put it in as evidence, so we don't need to cross-examine about it, because it's already been determined on oath. So why would we go into cross-examination? I fail to see how it does not expedite justice to have the matter answered in an interrogatory, rather than wait for cross-examination to do that. And the reason I respectfully say that we are guided by the practical wisdom in Mr. Mafusau's book is that if you prepare your case, part of the preparation is anticipating what you might do in the examination in chief of your own witnesses and what you might wait to do in cross-examination. But in preparing our case, we thought it important to have those questions dealt with in interrogatories so that we would not be burdened to have to ask them subsequently in cross-examination. In any case, Your Ladyship, if the questions are not relevant, how can they be allowed in cross-examination, if that is the position? If the questions are not relevant, if that is the position that's been taken, then they cannot be asked in cross-examination either.
Are you attempting to cross a bridge you have not reached?
Well, I believe you put that bridge there. Your Ladyship put that bridge there, and therefore I had to deal with that bridge. Your Ladyship raised the issue of whether it can be raised in cross-examination. And, respectfully, part of the reason why we cannot wait for that bridge in the preparation of our case is that in putting forward our case, we absolutely need that evidence. It is material to our case. And we need that evidence so that we can put it in as part of our affidavit, as part of our witness statement. And we respectfully ask your lordships to grant the relief. Indeed, my lords, as we indicate in our grounds B and ground C, the ruling also claims that
Counsel, please, I think some of these submissions are captured in the It's a statement of case.
Yes,
if you can highlight on some of them so that you wind up. Yes.
I'm winding
Okay.
up. I'm winding up. But I also had to respond to the questions of your lordships. My lords will see that it is stated that Rule 69C4 not only sets timelines, but it implies, and these are the words in the ruling, it implies that even amendments ought not to be sought and granted as well as joinder of parties. Now, my lord, so this is the legal basis on which that exercise of discretionary power is being exercised, that even amendments ought not to be sought and granted as well as joinder of parties. We are saying with the greatest respect that that is a fundamental error of law. Nowhere in CI 99 does it say that amendments ought not to be sought and granted simpliciter. Nowhere. No.
In any case, we granted an amendment.
I'm sorry.
We have granted an amendment in this case to the petitioner.
Because it is allowed in the rules.
So that is not what we meant.
Well, but that's what is stated in the ruling. It says it implies
the rule does not allow amendments, substantive amendments to the grounds.
My lord, I just read from the ruling. There's no qualification.
Yes, but that is not. That is just as you said. You can't go into our minds. You can't go into the minds of the rules of court committee members.
But we can go into the letter of your ruling.
Yes, so that is not what we meant. The rules does not allow substantive amendments to grounds and all that. Other than that, would we have granted you the amendment that you sought?
My lord, at the minimum, what your lordship just said suggests that your lordship should, at a minimum, review your ruling so as to qualify the reference to amendments appropriately. Because we expect nobody reading the ruling that you've given can see the word substantial in that. Nobody can see that. And in any case, in CI 99 does not. My lord, with respect, I leave my submission at the point that that statement, as it stands in the ruling, is not borne out by CI 99. I leave it at that, and it is obviously up to your lordship to determine ultimately whether indeed Rule 69(4) says or implies that even amendments ought not to be sought. My lord, with respect, I mean, the amendment that we sought and that was granted, I mean, was a very insubstantial and frankly a clerical error which was corrected. That should not be touted as a reason for somehow not accepting the argument that we are making. My lord, my final submission is that this court fundamentally erred in failing to appreciate that its discretion ought to be exercised in accordance with Article 296 of the Constitution. And that Article 296 makes it clear that where in this Constitution or in any other law discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. We are respectfully we are respectfully submitting that in respect of your discretionary power to grant leave for interrogatories, there was, with respect, a duty to be fair and candid, and not to act in a manner that is arbitrary or capricious. And our respectful submission is quite straightforward in this regard. Our respectful submission is that in terms of even a determination about the relevancy of the interrogatories as we had drafted them and the questions, in terms of a determination of relevancy, your lordship should at least have considered the terms of the questions posed in the interrogatories by reference to the issues in this case. Because if your lordships had made that reference to the issues in this case and to the questions that we have posed, with the greatest respect, it would be perfectly obvious that those questions were legitimate questions that required answers to be provided. So it is not sufficient just in one fell swoop for it to be said that the crucial issue of relevancy has not been established. With the greatest respect, it is not. It is not an exercise of discretionary power consistent with Article 296 for there to be such a disregard of the terms of our interrogatories.
My lords, we are opposed to this application for review, and we rely on the depositions in the affidavit in opposition and the statement of case that we filed. My lords, under CI 16, Rule 54, the court may review any decision made or given by it on any of the following grounds: exceptional circumstances which have resulted in miscarriage of justice, or discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not have been produced by him at the time when the decision was given. My lords, the submissions that we have heard today have not canvassed any new matter or exceptional circumstances for which this court's review jurisdiction should be exercised. My lords, what we have rather heard was a rehashing of the arguments that was before the court when the decision was taken on the 19th of January. In this regard, my lords, may I humbly read the decision of Adade GSE in the case of Mechanical Lloyd Assembly Plant versus Nati, reported in 1987-88, 2 Ghana Law Report 598, Supreme Court. My lords, with your kind permission, it says, let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer along with the evidence grounding it can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision will be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. A review jurisdiction is a special jurisdiction to be exercised in the exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in the exceptional situation where a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor as an automatic step from an appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. My lords, it's my submission that the arguments we have heard today by the applicant is just an emotional reaction to an unfavorable judgment quoting Adade, and therefore this application should be dismissed. That's my submission.
My lords, we are opposed to this application, and we rely on the depositions in our affidavits in opposition filed on the 25th of January 2021 and our statement of case filed on the same day. My lords, we wish to make the point from the very beginning that the court grounded its dismissal of the application for interrogatories on 3 key points, and not as counsel for the petitioner has sought to suggest on 1 point. The court raised the issue of relevancy, the issue of lack of matters in controversy, and then made the point, the third point, that CI 99 establishes strict timelines, and therefore the application will not, therefore Order 22 will not apply in this circumstance. So the first myth that has to be blown away is that the court never ever said or implied that CI 47 had been repealed or will never apply in a petition, in an election petition. This is a gross misconstruction.
He said Order 22. Order 22.
Yes, Order 22 or CI 40. I'm saying that my submission is that this interpretation is a gross misconstruction and an impermissible gloss that counsel seeks to put on what the court said. Now, my lords, my second point here is counsel has raised the issue of relevancy. Now, the issue of relevancy goes to the issues to be determined in the trial. And if your lordships look at the issues to be determined in trial as set out, it becomes very apparent that these matters that were raised in the interrogatories are not really germane to the issues to be determined in trial. The issues are: 1, whether or not the petition discloses any reasonable cause of action; 2, whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of the valid votes, as required by Article 63(3) of the Constitution. 3, whether or not the second respondent still met Article 63(3) of the 1992 Constitution threshold by the exclusion or inclusion of Techiman South constituency presidential election results. 4, whether or not the declaration by first respondent dated 9 December 2020 of the results of the presidential elections conducted on 7 December 2020 was in violation of Article 63(3) of the Constitution. And finally, whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election. My Lord, this is my submission that it is more than obvious that the issues sought in the interrogatories, are not really relevant in the determination of these matters. Secondly, my Lord, the court's second reason was that the issues sought in the interrogatories were not related to issues in controversy. That is, the issues joined by the pleadings. It is then only after these two fundamental reasons that the court makes the observation that in any case, or in addition, CI 99 prescribes strict timelines. Therefore, the court will not apply Order 23. In this circumstance, what is meant by this circumstance? That is, all the issues that have been looked at or discussed in the ruling. We all know that when you are doing interpretation, you do not just pick one sentence or paragraph out of a whole construction and make a meal out of it, as counsel for applicant seeks to do. My lords, let me then make the point that the reference to the Mona case, my lord, is misconceived and involves a deliberate attempt to put an impermissible spin on the Mona case for purposes of this application. In the Mona case, what the court held was that that rule in CI 74 that sought to take away the right of review was unconstitutional. Now, in order that the petitioner can suggest the relevance of the Mona case to the present application, he seeks to suggest that the CR 99 has impliedly repealed the right to interrogatories. That is the whole point. Now, if the court, as I've demonstrated, has nowhere said that CI 99 has repealed or amended the right to apply for interrogatories under Order 22, the whole argument of the relevance of the Mona decision falls flat. It crumbles, my lord. Now, similarly, my lords, we believe that it is important to recognize the point that every application that is brought for interrogatories must be decided on its own terms based on the general principles governing the grant of application for interrogatories. Therefore, it is again misconceived for counsel to suggest that because in 2013 an application for interrogatories were granted, automatically the Supreme Court is bound anytime an application for interrogatories is brought in an election petition to grant it. My Lord, that is poor logic.
We are used to our jargons. Maybe you can say that it's misconceived.
Very well, my Lord.
Yeah, we are used to our jargons. We are
my Lord,
other professions.
My Lord, my Lord is well taken.
Yeah.
I withdraw that point. But my Lord, I believe that it is completely misconceived to suggest that because in 2013 we were granted interrogatories, in this case we should be granted interrogatories. Again, my Lords, I want to refer to the Nigerian decisions. My Lords, and all the other decisions that were referred to in paragraphs 23, 25, and 26 or so of the statement of case. My Lords, in all those decisions, the court, exercising its discretion, held that in the particular situation, the applicant was entitled to the grant of interrogatories, and therefore held that the refusal was wrong. So, my God, Lords, one cannot just cite those examples to determine that the refusal in this particular case was wrong. Again, the applicant has the burden of demonstrating to the court how the refusal in this particular case was wrong. And furthermore, he has an obligation to demonstrate, one, that the error was a fundamental error, two, that fundamental error occasioned them a gross miscarriage of justice. And it's our submission that the applicant has failed to demonstrate these very basic conditions to grant a review. In the circumstances, my Lord,
and I would also respectfully, in relation to the point that counsel for the second respondent made about the exercise of discretionary power, I would also respectfully refer your Lordship to another authority of the Supreme Court in the case TDC and Musa against Atta Bafo. TDC and Musa against Atta Bafo. That is 2005 to 2006, Supreme Court of Ghana Law Reports, page 121. And in particular, His Lordship, Dr. Barnes' words at pages 152 to 3. Now, my Lords, you also heard counsel for the second respondent suggest that the issues that you have set down are the basis on which relevancy must be determined. With all respect, those issues that you set down were actually set down after the hearing of the application for leave. After. So, unless my learned friend was anticipating that those were the issues that would be set down, respectfully, those at the time of our application for leave, those issues had not been set down, and therefore it's illegitimate for him to claim that it is in terms of that application for leave that he's arguing. And finally, my Lord, the reference that is consistently being made to strict timelines under CI 99, respectfully, my Lords, we are saying that what the application sought to do was actually to facilitate those timelines, especially in terms of a judgment by March, being complied with, because we're not waiting for things to be done in cross-examination and so on. And my lord, if you wanted to be literal and mechanical about the meaning of those timelines, we would draw your lordship's attention to one very simple example. The timelines put filing and serving of process of the petition in January. For instance, January is stated in CI 99, Rule 69C4. It says January, filing and service. Are your lordships going to say that because we filed on the 30th of December and the process was served by the 31st of December, therefore we do not comply with the strict timelines in CI 99? Are your lordships going to say that? I mean, my lord, with respect, this very simple way of trying to interpret Rule 69C4 would lead to gross absurdity if we were to follow it.
All right.
Order, please, order.
Business, entertainment, sports, and news from around the world. Catch up with your favorite Net2 television, Oman FM and Ash FM shows on our website. Never miss an episode. Subscribe to our YouTube channel, Net2 TVGH, and hit the bell icon to get notifications when we upload new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2TVGH for amazing content right from your mobile phone or computer. Net2 TV, beyond the limit.
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency.
Watch the Presidential Diary this and every Sunday at 6 p.m. and repeats on Tuesdays at 2 p.m. only on Net2 TV. after many years of undercover investigations. I bring
another point for those who are monitoring. You realize that justice came in to say that reference should not be made to the personalities, but he still made a point nonetheless that once the individuals or once the court had upheld it, and the current law, the CI 99, that made changes to CI 16, does not take away the power to administer interrogatories. He doesn't see why the court should not grant those interrogatories. Then he goes ahead to read some of the questions that he had wanted to ask. The point about when did they discover, the EC chairperson discovered that errors have been committed, how did she detect it, and how did she proceed to effect all those corrections. He says if those issues are said not to be relevant, then he doesn't understand. Then at that point, when a member of the panel, Justice Professor Mensah, pointed out to him that can't he ask those questions during the cross-examination? Then he says, if it's not relevant, how do you expect me to even be allowed to even ask it during cross-examination? And that was the point that the reference was made to the bridge, that he's crossing a bridge that he's not at the point. And Mr. Chikata responded that indeed it was a judge who put that bridge in place, for which reason he's crossing that particular bridge. And so he makes the point that as far as they are concerned, contrary to the view that has been expressed by the lawyers in the case that administration interrogatories will drag the proceedings, he holds the view that to rather aid in a speedy determination of the proceedings, meaning that once they are admitted, and he made reference interestingly to a book that was authored by a member of the panel, Justice Marfus, that makes the point that once interrogatories are administered, they are taken as evidence and it is entered into the records of the court as evidence. And so he makes the point that will save time because you no longer have to lead evidence to establish those facts because they would have been admitted to and would be in evidence. And neither would you spend time in cross-examining facts. That's the other side that is supposed to be cross-examining it, would have obviously admitted to those facts.
Joseph, let's look at the arguments that was made in favor of this application earlier, the original application. What's different about today's argument from when it was first applied?
In terms of substance, it's not very different. The point he keeps making, and which was the essential part of his whole submission, was to make the case that the judges misinterpreted the rules that is the CI 99 and the CI 16 and the subsequent decisions that were taken thereof. And so that was the crux of his argument, to make the point that one, the judges were wrong when they said the questions were not relevant, and number two, they were wrong when they interpreted CI 99 to mean that because it calls for expedition, you cannot administer interrogatories, and to insist that interrogatories rather ensures expedition. And so in terms of the substance, it's not very different from the initial argument, but this submission virtually attacked the decision of the court on January 19 to make the point that that particular decision was contrary to law. It was a wrong understanding and appreciation of the law that the judges undertook, and that was why they have come to a review asking that the court just set aside.
Joseph, stay with me. I just want to remind our viewers that this election petition update is brought to you in association with Petrosol. Clean fuel in full quantity is always a delightful experience. DBS Roofing, we truly are your roof experts. And Koa Mixture, the immune booster for the general well-being. Now, due to hard times, we've become value hunters, but are we hunting for value the right way? Remember, your engine is more valuable than just cheap fuel. Be smart, hunt for holistic value. Holistic value is when you have quality fuel at the right quantity and at a fair price. At Petrosol, we serve clean fuel in full quantity at a fair price, and that is holistic value. So come to us, Petrosol, clean fuel in full quantity. And after several years of intensive research, DBS Industries Limited brings you roofing sheets to help complete your dream house in style. Experience the amazing touch of Colorlink Plus roofing sheets in 26 years, which means Colorlink Plus roofing sheets always stay clean and beautiful for you. And there's more. We're giving you a whopping 20 years warranty against fading and peeling. Visit DBS Industries Limited in Accra on the Spintex Road in the DBS building near Papaya Restaurant, or call their hotlines on 024-0844-444 or 054-3286-637. That's 054-3286-637, or just visit their other factories in Kumasi, Tamale and Takra. The DBS Industries Limited. We truly are your roof experts. The election petition update here on Joy News is brought to you in association with Petrosol, DBS Roofing, and Koa Mixture. Joseph Akable, our court correspondent, is on. We're running you through what the court has been dealing with. Currently, they are on recess, and they've been talking about the matter of reviewing their earlier decision on some 12 questions that the John Mahama's legal team is hoping that they can put to the Electoral Commission chair. We will be back to talk about what the other respondents in this case, the two other lawyers who are opposed to this application, have been saying. Stay with us.
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency.
Watch the Presidential Diary this and every Sunday at 6 p.m. and reprise on Tuesdays at 2 p.m. only on Net2 TV.
Log on to www.net2tvgh.com for your local news and politics, business, entertainment, sports, and news from around the world. Catch up with your favorite Net2 television, Oman FM and Ash FM shows on our website. Never miss an episode. Subscribe to our YouTube channel, Net2 TVGH, and hit the bell icon to get notifications when we upload new content. Interact with us and follow us on our pages on Facebook, Twitter, and Instagram at Net2 TVGH for amazing content right from your mobile phone or computer. Net2 TV, beyond the limit.
Do about not much. So the court will, from our point of view, will come out to say that they refuse the appeal or some what do you call it, the application for review. Going to be, I believe, will be dismissed.
Your sides, lawyers of your sides and representatives from your side have made the argument that some of these applications brought before the court by the petitioner are just ways and means of delaying this particular hearing and bringing a conclusion to this particular hearing. When you even listen to some of the arguments, it comes to that point where they say, look, it's about timelines and you'd want this to be done quickly. Do you still believe that the... Yes, do you, I mean, your side have always said that it's a tactics to delay the case. Do you still hold... Exactly. Do you still believe and hold the view that after listening to the arguments of the petitioner, these applications are still meant to delay this particular case?
These are applications, and the main substance of the matter, the petition, have not been even gone into, because they filed witness statements and statement of case and everything else have been done. And let's go to the matter quickly. I mean, the petitioner should not hang on, and it should be the petitioner who should be in a hurry to ensure that his case is heard expeditiously as possible. But rather, here we are, the respondents are saying that let's go on the matter instead of responding to applications upon applications which tend to delay the substantive case. I don't want to pass very bad judgment on what they are resorting to. But definitely we feel uncomfortable that why the delay? Let's get rid of the matter. Let's do away with it fast and get everybody doing what it's supposed to do. I think it's fair to say so.
What are your...
That's law. In the law court, sometimes our fair argument is that everything that they've done under the rules are allowed. They are not doing anything outside the rules and so forth. If you are not careful, sometimes you may be accused of abuse of the rules, in the sense that you apply here, and at the end of the day, it delays the trial of the matter. And if you are not careful, this is what is happening.
What are your expectations after this particular ruling is given?
I don't want to. No. But if I'm telling you from my own opinion, I think the petition will be dismissed at the end of the day, because I don't think it has any merit at all. Well, having looked at it, look at the pleadings and look at what has been put up and so forth, honestly, the issue is, did it substantially affect the results? If there was anything that was wrong, if there was any calculation, if there was any declaration that was, did it go to affect the substance of the declaration or the results of the election? I beg to say that, if I am not wrong, I beg to say that no. If that's not the case, then why are we wasting time in court? If you are not careful also, let me be very choosy on my words, it will amount to almost of a nuisance value. Not much will come out of it.
Thank you very much, Mr. Flay. That was National Chairman of the New Patriotic Party, MPP, Freddie Blay, who is here to also represent the second defendant in this particular matter, His Excellency Nana Addo Dankwa Akufo-Addo. Still with me here is my colleague Sixtus Don Ulo. Sixtus, we're discussing the arguments put out by Mr. Chikata. You made mention of some of the 3 key points he put out, issues of relevance. Can you continue and explain to us what were the arguments of the relevance arguments he made in the court?
Well, Mr. Chikata said he was at a loss as to how the interrogatories they have, they still hold, are not relevant to the question of determining the validity of the election and declaration of President Akufo-Addo as having won the December presidential poll. He said that if you look at all the questions that they have, and you remember there were like 12, 13 questions and all of the questions, he argued, have specific and are specifically tailored to meet the question of a valid election and to help them narrow down and focus on determining that key concern of whether or not the election was valid and whether or not any of the candidates obtained the constitutional benchmark for declaration as president, and whether or not the Electoral Commission itself, in the conduct of the polls and declaration of the election, did it in consonance with the constitutional mandate imposed on the commission. And so for Mr. Chikata, he cannot understand how and why the court would have said in that ruling that the interrogatories were not relevant. Again, there was the question of when to address these interrogatories also came up. You recall that it was one of the key arguments that Mr. Akuto-Ampao, lawyer, lead counsel for the second respondent, advanced when he said at the time of hearing application for leave to serve the interrogatories, he had argued that these are not questions that you cannot ask during cross-examination. These are questions that can always be asked at any point in time. If you don't do it now, you can do it during cross-examination. Again, the same argument we heard from Mr. Chikata in response to this, we heard it again today. And the argument is that in any case, the issues, the interrogatories that are to be served will help them narrow down and focus the case, so they may not even have to get to that during cross-examination. Cross-examination could be it could be lengthy, it could be laborious, and so his argument was that if they had the opportunity to address these interrogatories now under oath, they will not have to spend time during cross-examination going through these interrogatories. And this also puts against the question of a speedy trial, the question of keeping in line with the timelines set or laid by statutorily set for determining the election petition. And from there, you could see the passion with which he made the argument that, and again, this is coming from an argument he made earlier during the determination of the application for leave to serve the interrogatories, that you can never really say that because you are in a hurry to dispose of a case, the issues that would support or aid the delivery of justice should be sacrificed. You would recall the last time he made that statement, and today he came with a case from the Nigerian experience when Nigeria went into a similar petition between Abubakar and Yaradua, and the matter went to court. The question of interrogatories during the CMC, this same question of whether or not the parties should be allowed to serve the interrogatories came up. And the concern of speed versus justice came up. And in that decision by the Supreme Court of Nigeria, the court said that you cannot sacrifice justice on the speed of altar. Simply put, you cannot say because you are in a hurry to determine a case, the instruments or the avenues or the totality of the evidence that you would need to be able to deliver justice should be sacrificed or be dispensed of. And so Chachu believes that that particular decision of the Nigeria Supreme Court reinforces the position that he's made all along, that we should not just be in a hurry to have a determination of the election petition 2020, but that we should also allow the opportunity for the party, the petitioner particularly, to present whatever documents, materials, file whatever processes that would aid the court in making a fair and a just determination in this matter. But the distinction we must make here is that when it comes to case law, in fact, by now we would have all observed that the lawyers would make their argument backed by law and precedent. And this precedent is what the court had decided in previous cases with facts similar to the present circumstance. Now, in all of the cases that have been cited by the petitioner relating to the Supreme Court of Ghana, it means that those decisions are binding. They call it. They have a binding authority on the court, except where the Supreme Court decides to depart from its own decision, an earlier decision. Then it says it gives reasons for same. You get it? Or that's where the facts, the set of facts between case one in which the decision was given, is not entirely as the set of facts of the case, the present case in which the argument is being made for the case of precedent. Again, that is different from the case lifted from Nigeria, and the force of it is different from the case lifted from Nigeria and the attempt to, invite the court to make a decision in Ghana based on that decision that was made in Nigeria. The lawyers will call it persuasive authority, that the bench can only be advised, be guided by the decision of the Supreme Court in Nigeria, but it is not binding on our court. So it may have been a beautiful argument, in fact solidly made to support a principle and the cause that Mr. Chachu Chikata is championing, but it is not compulsory for the Supreme Court of Ghana to go by that decision. And so the Supreme Court may come back and say, well, we have listened to you, we agree with the Supreme Court in Nigeria, but this is Ghana and we are not really bound by that decision that was taken in the Supreme Court in Nigeria, and so we are taking a different route. And so there is the difference. There is that if it were a Ghana case, we could have said that, yeah, there's a clear-cut authority on this, which would be a key influence on Mr. Chachu Chikata's argument. But as it stands now, it only carries that advisory authority that the judges will say, well, we are advised, we are guided by this, but we want to go a different way.
When you listen to the concluding remarks of the lawyer for the first respondent, Justin Amanuvo, you realize that he said that he believed that this particular argument made in respect to the the review application was made from an emotional point of view. Why did he reach that particular conclusion when you look at his argument where he states that, look, for review cases, you believe that there should be something extraordinary you should make to turn the decision of the court, not just to come and rehash your argument. Why would he reach that particular argument?
Exactly. You know, we in the morning when we had the conversation talking about the application for leave to serve the amend and serve the other processes that we discussed in the morning, we said that for you to come for a review, the grounds must be compelling. It's fundamental. It's primary. You cannot do without that. It's different from the normal appeals that we'll see the parties go in for. Now, the grounds must be compelling, and they must also point to law. That you don't come and make some argument based on a certain emotion, not to take any side. Now, again, whether or not the ground is compelling will be based on the set of facts, a set of laws that you bring to remind the court that, look, we have 1, 2, 3 decisions that told this line, but which decisions you have decided to depart from without any reason, legal basis. You get it? But if this is not visible, then the other people have a cause to worry. So if you observed the arguments of both Mr. Amenuvo and Mr. Ampao on this in opposition to the application for review, you would have noticed that they kept emphasizing that the grounds on which you are coming. And for all you know, that is one of the reasons Mr. Chikata wanted leave to add more grounds for a review of the application.
On that, you realize that it was interesting during his argument where the Chief Justice mistakenly referred to one of his points he had filed as part of his supplementary argument or statement,
yes,
thinking that it was part of
the process.
You had Mr. Chikata's response,
yes.
Quite an interesting response,
yes,
wasn't it?
Yes, this is why you should have, if you had not thrown out this would have been part of it, something like I think he apologized for a comment that the court did not deem fit, but he said he was only trying to lighten the already tensed atmosphere, and so the court shouldn't take it so hard on him with that particular comment. Again, you see that at every turn on the way, Mr. Chikata had a way of referencing some of the grounds or some of the materials that they wanted to submit if the application had been granted in the morning. So in a way, he keeps coming back to the point that, see, if you had allowed me to do this, this question wouldn't have come up. More like, I told you so. You get it? Then again, if a ruling has been given, it is given. It is the decision of the court, the order of the court, and the parties can only abide by it.
With the judicial review and the addition of 2 judges, I'm sure a lot more people will be looking out at the reactions and comments by the 2 additional judges, Justice Henrietta Mensah-Bonsu and Justice Tanko. You would realize that during this particular sitting, the sitting to hear the review application, there was a lot of questions and a lot of back and forth between Justice Mensah-Bonsu and Mr. Chachu Chikata. What does that tell you with the addition of the 2 judges? Is it that she needed a bit of clarity in a lot of things to be able to make up her mind, or she wanted to know whether the arguments Mr. Chikata was making were one which was just doing as referred to as from the second or lawyer of the first petitioner?
Let me look at it this way. In this particular hearing, Mr. Chikata had an uphill task of doing 2 things. Convincing the original 7-member panel that the decision they took in the earlier ruling was wrong and they should change their minds. They had all the facts available to them. They had all the laws available to them, yet they took that decision. It is now Mr. Chikata's duty to tell the court that the decision you took based on the set of facts and laws available to you was wrong, so change your mind. This was a 7-0 decision. The second duty Mr. Chikata had was to convince the additional judges, the 2 other judges, Professor Mensah-Bonsu, my own lecturer, and Justice Tanko, that your brothers, that is the original 7, made a mistake when they decided otherwise on this matter. So correct them. Now these 2 people, it is assumed that they don't have the set of facts. This is their first time encountering the case. So they have to go back, look at the background to the case, the set of facts, laws that were presented in the first instance, and the decision went against the petition applicant. The 2 of them have to go back, study that, and then put the questions to Mr. Chikata for clarification in the particular instance to make them or help them reach a decision. And Mr. Chikata doesn't just need the 2 of them to be able to overturn this ruling. He needs the 2 of them plus 4 others, let's say 4 others. That will make it 6. Or even 3 others, that will make it 9. So if Mr. Chikata is able to convince 3 out of the original 7, he's won himself 5 on his side, and that means that he's able to get his application granted, and that earlier decision will be overturned. But if Mr. Chikata only succeeds in convincing or winning the 2 additional justices to his side, then he's still lost. It would be a 7-2 majority, and that means that the decision will be maintained. And so it is not surprising that you found the 2 additional justices being the ones aggressively, questioning Mr. Chikata and all of that, because they need more information. They need to further understand the case. It would have been different if Mr. Chikata was coming with this application for review on the strength of, say, a 5-4 decision against him. That would have been so easy for him. But it is not the case. Now it's as if he's starting all over to argue the case that he had made. And in addition to arguing that case, providing further insight for the benefit of the two additions. So it is really a daunting task for him.
I don't know what you made of the time where Mr. Chikata and Justice Mensah Bonsu went on and on over introducing or using the interrogatories he wanted during cross-examination and crossing the bridge before time. And
Mr. Chikata said, I'm only crossing the bridge because you put it there.
Those were quite interesting times when you were listening to this particular case. And there was even a point where Mr. Chikata made reference to a book written by Justice Mafusao.
Yes. And you realize the curiosity that generated, more like you want to use our own against us. Yes. You see, and as if by some deliberate design, Mr. Chikata kept, emphasizing that particular point, that guided by the wisdom in the book, authored by Justice Mafusao. Well, they said they want to refer to him as the author as he then was. They want to be guided. All of it to remind the court that this is the admonition, even though the book is not binding on the court. This is the admonition of a brother, and which admonition we abided by, and by which admonition we're able to put this together. And so also be guided by that same admonition into reaching a determination that is favorable to my side.
You had my colleague Sixtus Don Ulo, who's breaking down some of the arguments made in court this afternoon with regards to the application for review on the court's decision on an application to allow some interrogatories at the court, which was dismissed earlier. Would continuous coverage of the election petition and would go and bring you a recap of proceedings in court some few minutes ago.
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency. Watch the Presidential Diary this and every Sunday at 6 p.m. and repeats on Tuesdays at 2 p.m. only on Net2 TV. Welcome to
have in mind that the first justices that sat on the first case, there's been an addition of 2. So if it's going to be granted, on what grounds would it be granted? If it's not going to be granted, on what grounds will it not be granted? We are not speaking specifically to this, but if you seek a review,
you're talking about the general review jurisdiction of the Supreme Court.
Exactly.
Reference first and foremost needs to be made to Article 133 of the 1992 Constitution, which is captioned "Power of the Supreme Court to review its decisions." And 1331 says the Supreme Court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of court. Then Article 1332 then says the Supreme Court, when reviewing its decisions under this article, shall be constituted by not less than 7 justices of the Supreme Court. So that's what the Constitution says. It sets out generally the power of review of the Supreme Court. If you look at the Supreme Court's rules, CI 16 of 1996, which is the original Supreme Court rules, that's the first Supreme Court rules that were enacted in the aftermath of the 1992 Constitution. Part 5, which is entitled Review, which is from rules 54 to 60 thereabouts. 54 says the court may review any decision made or given by it on any of the following grounds, 2 grounds. The first is exceptional circumstances which have resulted in a miscarriage of justice, and the second is the discovery of new and important matter or evidence which after the exercise of due diligence was not within the applicant's knowledge or could not be produced by him at the time when the decision was given. So what the petitioners are saying is that their application for review is grounded on the first ground, that there were exceptional circumstances which have resulted in miscarriage of justice. That's why if you look at their grounds of review, they are talking about the fact that the court fundamentally erred in talking about the fact that they won't apply Order 22 of CI 47 because of the strict timelines and the expedited manner in which CI 99 expects that election petitions are dealt with henceforth. They are also talking about the fact that the court also fundamentally erred when they talked about the fact that even amendments could not be granted because according to them, nothing in CI 99 suggests that amendments cannot be granted. The only thing that talks about amendments in CI 99 is about the petitioner not being allowed to file amendments that alter or seeks to undo any grounds that they have set out in their petition, or the respondent also doing saying that seeks to alter any of their answers to the initial petition. So that's something that you're talking about. You're also talking about the fact that, and this is all part of the exceptional circumstances which they feel have occasioned a grave miscarriage of justice, that the court fundamentally erred in failing to appreciate that its discretion ought to be exercised in accordance with Article 296 of the Constitution, which requires bodies, judicial bodies, including the courts, to exercise their discretion in a fair and candid manner. So those are the grounds, and that's what they believe are the grounds that suggest that a grave miscarriage of justice has been occasioned as a result of the dismissing of their initial application for the grant of interrogatories.
All right. And then, so it means that the court can review its own decision?
Yes, that's what it means. The court can, I quoted Article 133 of the 1992 Constitution, which makes it clear that the Supreme Court may review any decision made or given by it on grounds and subject to conditions that are prescribed by the rules of court. And the rules of court have made those grounds given 2 general grounds: exceptional circumstances that result in miscarriage of justice, or where you discover some new and important matter or evidence that after due diligence you could not produce or wasn't within your knowledge during the initial application or the initial point in time where the matter was being heard. So yes, the Supreme Court may review its own decisions, and there are numerous instances that exist where the Supreme Court has even given judgment on a particular matter, but an application for review is nonetheless made, and the court has sat on that particular matter to review their decision. A typical example is the case of Rosemary Ekwam and Kwame Pianim, which was a case that bothered on the 1996 election and whether or not Mr. Kwame Pianim, who was one of the leading candidates in the primaries of the New Patriotic Party, whether he was qualified to run as president or he was eligible to be president because of the fact that there existed a judgment that had been given by a court which sort of implicated him in an offense involving the security of the state, I believe in the early 1980s or late 1970s there about. And the court held that indeed initially that Mr. Kwame Pianim, on the basis of the Constitution's requirements of eligibility, that you could not hold office as president if you had been convicted of an offense involving the security of the state, that he would not be eligible to be president. And the matter had been brought even before the election had been done in terms of the primaries of the NPP, because according to Rosemary Ekwam, if he was elected as a candidate of the MPP, it was possible that he would be disqualified from contesting in the 1996 general elections. And dissatisfied with the decision of the Supreme Court, there was a review application that was made, and the court sat on that review, but essentially came to the same conclusion that the earlier panel had concluded in terms of the ineligibility of Mr. Kwame Pianim for running for office as President of Ghana.
Can we have any justice at all who ruled earlier granting for the case to be dismissed, and then in the review, that same justice this time around accepting what the petitioners have put across?
I mean, it's all a question about the arguments that are made in any particular instance. So you can make you can have an application which is dismissed, for instance, and you seek review and you make your arguments, and obviously other justices join the panel. We saw the 2 justices join this particular panel to hear the review, and it's possible. I mean, we can't go into the minds of the justices, but they are swayed or not swayed by the arguments that counsel presents. So it's possible that in one instance you may decide one way, but you may be persuaded subsequently by other arguments which may be superior, which you may end up changing your mind. There's nothing wrong with changing your mind. In fact, we have instances where justices of the Supreme Court have changed their mind or have decided in one breath in line with a particular position, but in a subsequent case, not necessarily a review, so it's not particularly applicable. But that's just to show you that it is possible that a justice or a judge generally may make a decision on a particular matter at some particular point in time, and subsequently a different case will come, similar facts, but may arrive at a different decision or a different conclusion, essentially reversing his own position on that particular matter. So there's nothing new or nothing necessarily wrong with that.
All right, so it means that a justice can actually go back against his own earlier ruling in a same
case. It's possible, depending on the arguments that are made. It's all, and that's what we need to dispel in terms of in the minds of the general public. You know, we hear all sorts of things, biases and all that. But the justices do not sit there to do dispense justice on the basis of likeness or dislike for one party or the other. It's based on the arguments that you make. If your argument is superior enough to convince any judge, for that matter, they very well may side with your arguments. It's just a question of perspectives, and it's a question of you making arguments backed by sound legal reasoning and legal authorities to sway the judge one way or the other. So that's the point that we need to make and make it quite clearly for everyone.
All right. How many reviews can the Supreme Court actually hear?
You mean how many reviews?
Yes, how many reviews? Let's say there's a ruling and you're not satisfied. You go for a review. How many of such reviews can you go for you to be satisfied?
So the review jurisdiction of the Supreme Court is a special type of jurisdiction. And we need to make it clear that a review is not the same as an appeal. And you saw counsel talk about that and acknowledge the fact that it is not as though you are trying to get a second bite at the cherry. A review is simply you going to the court, asking the court to review its own decision on the basis of certain exceptional circumstances that may have occasioned a miscarriage of justice, or you come across some new sort of information or evidence that you did not have at the initial time the application was being heard. So it's not something that you can abuse. And short of the rules or the law specifically prescribing that you can go for 2, 3, 4 reviews or something of that sort, it is my humble respectful opinion that once you have filed for a review and extra justices are brought to hear that particular review, it ends the matter there and then. Remember, the Supreme Court is the highest court of the land.
Yes.
And they have given their decision, you are dissatisfied, you are exercising your constitutional right as it may to ask for a review. The court comes back and gives its decision in respect of that review. So for instance, in the Kwam and Pianim case, when the review application was heard and it was decided, that brought matters to an end. So I hope that answers your question.
If you're not satisfied with the review of the reviewed, what do you do?
It's the highest court of the land. It's given its decision. I mean, you live with it because the court is that branch of government that is supposed to tell us what the law is. You know, you have the legislature, the executive, the judiciary is that branch that interprets and the law, tells us what the law is essentially. So if the Supreme Court is telling us that this is the law of the land, or this is the position of the land, you may think that it is erroneous, but until a subsequent case, which may be on all fours, has come before the court, where the court has an opportunity to review itself, in quotes, using review here loosely, or change its position, that remains the law. That ends the matter there and then. If it has to do with, for instance, a human rights situation, a human rights case, for instance, Ghana is a signatory to the Banjul Charter, the African Charter on Human and People's Rights, for instance, which provides for an African Commission on Human and People's Rights. Subsequently, there's the African Court on Human and People's Rights. So, for instance, under the African Commission system, it used to be the situation that once you had exhausted domestic remedies within your domestic jurisdiction on a particular matter, if you feel your rights are being violated, will be violated, or have been violated, and you exhaust all domestic remedies in the sense of you essentially seeking redress in the High Court, you were not satisfied, you sought redress in the Court of Appeal, you were not satisfied, then you further went on appeal to the Supreme Court, you were not satisfied by the decision of the Supreme Court. Then under the Banjul Charter, you can bring an individual communication before the African Commission on Human and People's Rights to hear that particular matter. And I believe that it's been done several times. The case of, I believe it was Chachuchi Kata's case, also went all the way to the African Commission on Human and People's Rights, which essentially held that he had not exhausted domestic remedies, and as a result, they did not have jurisdiction. So those sorts of opportunities exist in some types of cases, like the example I've just given you, in terms of human rights, for instance.
You mentioned earlier that we need to declare that review is not the same as an appeal. Help us to understand the two.
So an appeal, in simple terms, an appeal is where the court saying has, and let me use an example. You have a land matter, which went to before the lands court or the lands division of the High Court. The court has adjudicated upon the matter and declared or given its judgment on the matter that the land belongs to A or belongs to B or whatever orders that the court has given. Then you are dissatisfied with the decision of the High Court because you believe that in actual fact the land belongs to you. So you file an appeal with the Court of Appeal or at the Court of Appeal to hear the matter again, essentially take a look at the decision of the High Court and reverse itself. And for an appeal you need to have grounds of appeal. Some of the grounds of appeal that you usually see is that the trial judge had misconstrued the law or things of that sort. So the Court of Appeal...
Dr. Agyapong, just we'll have to quickly just pause it here. I understand the justices are just coming back into the courtroom, so we'll move over to the Supreme Court. When we are done, we'll get back and continue with our discussion.
Very well.
All right, thank you very much. So we just heard from Dr. Agyapong, who is a lawyer, and he's also a law lecturer and the head of law centers at the Gimpa Faculty of Law. Let's take you back to the Supreme Court. The justices are getting seated.
All rise.
This is the ruling of the court. The review jurisdiction of the Supreme Court, as conferred by Article 133, Clause 1 of the 1992 Constitution, and regulated by Rules 54 to 60 of the Supreme Court Rules 1996 CR16, has set down the threshold that the applicant has to satisfy in order to succeed in an application for review. It is a special jurisdiction conferred on this court. The threshold are A, exceptional circumstances which has resulted in miscarriage of justice. B, discovery of new and important matter or evidence which after the exercise of due diligence was not within the applicant's knowledge or could not be produced by him at the time when the decision was given. We have read the processes filed in this application and have listened to counsel. We are not satisfied that the applicant has met the statutory requirement of Rule 54A of CI16 in order to succeed in the application for review of the ruling of this court dated 19th January 2021. The application fails and it is accordingly dismissed. The panel will be reconstituted to give further directions for the trial of this petition.
As the court pleases.
No, you could bring it. You bring it there. You bring it there. Yeah. Yes.
All rise.
You will resume your seat, please.
Presidential Diary, brought to you by the Communications Directorate at the Presidency.
Watch the Presidential Diary this and every Sunday at 6 p.m. and repeats on Tuesdays at 2 p.m. only on Net2 TV.
The issues that borders many Ghanaians here and around the world. The politics.
I am fully committed to being fair and impartial.
The current affairs. The very survival of our nation is what is at stake in this effort that the soldiers are doing. They're not doing it just for themselves. They're doing it for all of us. Investigations and crossfire.
Today, inshallah, there's no excuse for any student in the Zongo community not to have education.
The show is The Secret. With me, Kweku Anand, your host, only on Net2 Television.
Make a date with Kweku Anand on the seat of accountability, performance, and justice on Net2 TV.
The economy, politics, sanitation, agriculture, education, join me Monday to Friday as we dialogue on issue-based politics, live on the Dialogue Show.
Watch the Dialogue Show from Monday to Friday at 7:30 a.m. to 9:20 a.m. only on Net2 TV. Net2 Television, beyond the limits. Documentary showing Monday to Friday at 5 p.m. to 6 p.m. on Net2 TV. Net2 Television, beyond the limits.
Yes. By court, this court stands adjourned to tomorrow, the 29th of January 2021 at 10 o'clock this time, a.m. for hearing. Yes. Yeah, that's all. Yes, for hearing. Please, those who have already given witness statements may be put in the box, witness box tomorrow. Okay, thank you.
Rise.
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency.
Watch the Presidential Diary this and every Sunday at 6 p.m. and repeats on Tuesdays at 2 p.m. only on Net2 TV.
Welcome to the Presidential Diary, brought to you by the Communications Directorate at the Presidency.